Hi, everyone, and welcome back to Becoming Counsel. Today, we're going to talk about a torts essay question, specifically an amusement park accident. And we'll cover three different claims associated with it: imprisonment, negligent, and negligent infliction of emotional distress. So let's get started with the fact pattern. So let's say John, he's 8 years old, and his mom takes him to the local amusement park for his birthday. Now his mom is pregnant and tired, so she's sitting on the bench about 100 or 200 yards away from the park's rides, and basically John is just going into the lines and riding the rides by himself. And so John jumps into the car of one of these rides, and essentially the attendant of the ride locks him in with a safety bar. Now the ride starts, and a few cars behind him, there's two young boys. And let's just say they're around the age of 5 or 6. And they start rocking their cars back and forth, screaming, laughing, making a lot of noise. Now the attendant sees this, he hears this, and he does nothing. Now, essentially, the ride gets started, it ascends up, and then it starts to descend. The boys behind John start rocking their cars even more aggressively, and they rock it so hard that the safety bar breaks, it pops open, the boys fall, and on the way down, they hit John. Now the two boys are severely injured. The attendant basically finally reacts. He stops the ride, hits the emergency alarm, calls security, an ambulance rushes in to get the two boys out of there into the hospital. And the mom is, sitting, a couple hundred feet away. She freaks out. She doesn't know what's going on. She runs towards the ride. But by the time she gets close, there's a crowd. She can't see anything. Somebody in that crowd says something along the lines of, "Oh my God, I think that kid died." Now, the mom can't get through the crowd, but she's panicking, right? She doesn't know who's been hurt. She doesn't know what's happened to her son, John. She is freaking out. Now, let's say 10 minutes pass. By then, the two boys are put into an ambulance. They're taken off. And John and everybody else on the ride are still suspended in the cars. Now, now that the emergency's over, they're begging to be let down. But the attendant won't restart the ride to let them get down, and he doesn't explain why. Now, another 30 minutes go by before a manager finally shows up, and the manager doesn't do anything besides telling the attendant to start the ride so that everyone can get off. So that's about 40 minutes after the accident started. John finally gets off the ride, and the mom finally finds him. Now, both end up in the hospital. John has some minor injuries from being struck when the boys fell. And then the mom has basically a ton of stress. And that stress actually triggers a miscarriage. So, a pretty significant impact to the mom. Now, in addition to that, there's some national safety records you should know. So, in this type of scenario where somebody's rocking a car aggressively and then falling out, this type of scenario has only happened once in the last 40 years across the entire industry. So this doesn't happen often. That being said, after this incident, John and the mom both sued the amusement park. And in that lawsuit, the amusement park essentially concedes that the attendant was acting within the scope of his job the whole time. So if you see this fact pattern, on a test, you'll get a couple questions associated with it. And now the questions might vary, but directionally, they'll ask you if John experienced false imprisonment while he was on the ride. They would say, could a court find that the amusement park was negligent for not stopping the boys when they started kind of making the ruckus? And then number three, they might say something along the lines of asking if the mom was entitled to damages for her emotional distress and then the resulting miscarriage. So let's attack each of those problems or questions one at a time. We'll start with false imprisonment. And we're going to use the IRAC method. So issue, rule, analysis, and conclusion. So in terms of false imprisonment, the issue was essentially, was the attendant justified in refusing to let John off the ride once the emergency situation was over? So there's a couple rules we'll have to understand. So number one is false imprisonment. So false imprisonment is the intentional confinement of an individual. That individual needs to be aware of the confinement when it's happening or be harmed by it. And there has to be no other escape route available for that individual. So that the plaintiff in this case would not be able to genuinely leave without the defendant's help or, the defendant withholding help. And so that's essentially kind of the first piece. The second piece related to false imprisonment is there is a defense for it. So, like an exception. The exception is if there is an emergency occurring and you have to essentially stop or hold people back to prevent additional harm or to protect them, that essentially means that there's implied consent, but that implied consent has a clock on it, right? It doesn't last forever. It's just a time period that's considered reasonably necessary. And then finally, in regards to this false imprisonment claim, we have to just talk about employers can be vicariously liable for an employee's conduct if that conduct happens within the scope of their employment. So those are the rules. So let's break down the analysis, right? So when you actually look at it, initially John consented to the ride, right? He consented to be confined in that car, and that's not in dispute. Now, the confinement goes from a consented confinement to implied consent when the ride is stopped and there's an ambulance coming to pick up the boys. Now, once the boys have been picked up and that emergency situation has been addressed, there's a whole nother 30 minutes where John and the other riders are on the ride. They are literally begging to get off, but essentially the attendant refuses to restart the ride, gives no explanation, doesn't say that there's a risk, doesn't say, XYZ has to be addressed before he turns on the ride. He basically says nothing. And as an attendant, he knows that nobody in those cars can get free safely without him turning back on so that they can finish the ride. Now, the attendant and the park can argue implied consent because there was an emergency, like I mentioned, but the main key here is that emergency time period, right, has ended. And so that 30 minutes that occurred is essentially false imprisonment because they're confined, they're aware of the confinement, and they have nowhere to go. Now, it's important that we need to call out, just from a scope of employment perspective here, the amusement park is not denying that or is not stating that the attendant's conduct was outside the scope of their employment. Therefore, they're acknowledging that they are vicariously liable for the attendant's conduct. So in conclusion here, for false imprisonment, a jury could find that the amusement park falsely imprisoned John via being vicariously liable for their employee's conduct. So that was the first issue. The second issue is negligence. So going through the IRAC method, the issue would be, did the attendant breach a duty owed to John by failing to stop the two younger boys from rocking their car? Now, from a rule perspective, negligence needs four things: duty, breach, causation, and damages. Now, there is a more specific rule associated with that can be easily forgotten, but the law does not impose a duty to act to prevent harm from a third party. But when you gather the public for profit, which an amusement park is, you now have a heightened duty to take reasonable steps to protect your patrons from foreseeable harm caused by other people on your premises, and not just from the equipment you own. So let's look at it from the analysis perspective. So John and the mom are invitees, right? They're there for the exact reason that the amusement park exists, right? They bought tickets, they're there to enjoy the park. So that triggers the heightened duty that the park has. Now, the attendant in his own activities is seeing the boys rock the cars. He's seeing them screaming and laughing, and they're kind of going overboard. Well, rather than pausing the ride or correcting them or verbally kind of giving them some feedback, he does nothing, right? And so you can make the argument that the attendant had the duty to take reasonable steps to protect the patrons for foreseeable harm, and rocking the car and screaming and kind of doing the activities the boys were doing, especially unsupervised, that was definitely putting people at risk, if not others, at least themselves. And so by doing nothing, you can tell the attendant did breach his duty in regards to those people. Now, one thing to kind of counter from that perspective is the amusement park can push back and say this type of scenario has happened one time in the last 40 years. And so you might argue that this specific thing is not foreseeable, but really that's not the real argument here, right? The real argument is if you see two young children that are unsupervised violently rocking a ride car in real time, a reasonable person would see that as dangerous or something that has the potential of being dangerous. And now let's talk about that from a negligence perspective. So there was a duty, the duty was violated. From a causation perspective, failure to stop the kids from rocking led to the safety bar unlatching, led to the boys falling, and then led to them hitting John on the way down. Now, that defines causation. And then from a damages perspective, John did suffer minor injuries, and that required a hospital visit. As such, in conclusion, for this issue, a jury could probably find the amusement park negligent and liable to John for the injuries that he suffered. So now let's talk about the third item, the negligent infliction of emotional distress. So here the issue is whether or not Thrive Crow breached a duty to the mom in regards to a potential claim for negligent infliction of emotional distress. Now, from a rule perspective, NIED is a couple different things, right? It has a couple different elements. The first one is essentially the direct victim path, right? So the defendant creates a foreseeable risk of harm to the plaintiff herself, and she's in the zone of danger, and she suffers physical manifestations of the distress. Path two is the bystander path, right? And so it exists for people outside of the zone of danger, but those individuals can still recover if they're closely related to the person who's hurt. And they were present at the scene and they perceived the event through their own senses, meaning they actually saw or heard it happening, not that they heard about it afterwards. Now, most jurisdictions will require some kind of physical manifestation of distress, though the modern trend is kind of chipping away at that requirement. So let's analyze that now that we know the rules. So from a direct victim path perspective, we can rule that out quickly. The mom was over 100 yards away. She was never in the zone of danger herself. So that kind of path is closed immediately. So let's focus on the bystander path, where the exam and your professor really wants your attention. So element one is they have to be closely related. Well, that's an easy yes. She is John's mother. Element two, she has to be present at the scene. Now that's where there's some friction there, right? The mom wasn't exactly in the location where it happened. She wasn't on the ride. She was 100 yards away or more. She heard the alarm afterwards and ran towards it. So she wasn't really in the zone of danger. So that element's a little weaker. And then element three is she has to perceive the event through her own senses. Now that's another element that is hard to prove. And so there's no evidence in the fact pattern that she saw the boys fall. She did not see John get hit. All her information was essentially secondhand, right? She heard it from strangers. She was not able to visualize anything directly. And so because of that, when you look at it, sure, element one has been addressed. Element two is, let's just say, weak. And then element three is not even there. You can make the argument that the NIED case is, let's just say, not really strong at this point. So before we kind of go to the conclusion, it's important to know what the mom suffered. So she did suffer something extremely devastating, right? A miscarriage is a pretty significant event, and it being brought on by the stress of the moment is foreseeable, right? You can make the argument that it's reasonably logical that something that significant can result in the miscarriage, and there's no other evidence of any other health or any other reasons for that miscarriage. But the key thing about this doctrine is it isn't just asking what she suffered, it's did she suffer the right way and under the specific structural requirements of bystander recovery. And so even though it's a horrific scenario and situation, she's missing two of the three key elements for an NIED claim. And so the sympathetic factors and facts are there kind of like as a distractor, right? To say, oh my God, this is such a significant thing. She should get some kind of reparations for it. She should get something to make her whole. But the exam isn't testing you on that, right? The exam is like, here are the elements. So just kind of keep that in mind. So in conclusion, you can say it's very unlikely that the park will be liable for the mom's NIED claim. And so it's very unlikely that the mom would get any damages for her emotional distress or for the resulting miscarriage. So that's kind of it on a high level. So as you can see, there was a fact pattern. There were 3 questions. So each question got its own IRAC. And, hopefully that really helps you kind of understand how to attack a torts question. Obviously, if you have any questions, feel free to reach out. Thank you.